Hello, everybody. Adam Parks here with another episode of Receivables Podcast. Today, I am here with an industry legend, Mr. Mitchell Williamson with Barron Newburger. How you doing today, Mitchell?
Good.
I really do appreciate you coming on and having a chat with me this morning. And I've had the opportunity to spend some time with you at the RMAI summits and other conferences throughout the years. But for anyone who has not been as lucky as me, can you tell everyone a little bit about yourself and how you got to the seat that you're in today?
How I got to the seat today, and I'm in today. Well, it's a long and winding road, as is everything. I started out. I decided I wanted to be a lawyer back when I was in high school. I was on the debate team, and I had an instance which I'll talk about. I was at a youth group dance. As I said, I was on the debate team. The topic of that year was the Constitution and the First Amendment and the Second Amendment. I was at a conference, at a dance rather, social event. Went outside up in North Jersey, went outside with two people walking around to take a walk. At that time, it was back in the 60s. We were doing things a little differently then. I had a corncob pipe. I'm sure most of the people listening will know what I'm talking about, but back then they actually made pipes out of corncob. They'd take a corncob about 2 inches, hollow it out, and put a stem in it, and you could smoke out of it. And I was walking with these two people, a guy and a girl that I just met, and the guy asked me, could I borrow your pipe? And I said, I didn't think about it. I said, sure. 3-4 minutes later, somebody jumps out of the bushes. It was the local police. He had put marijuana in the pipe. And they'd been watching him because he was a notorious smoker. And he asked him, where'd you get that? Where'd you get the pipe? And he turned to me and he goes, him. And I'm thinking, now what do I do? This is not good. I wasn't smoking. I didn't have anything on me. But as fate would have it, I had argued all that morning about the Constitution and constitutional due process, et cetera. So I started reciting the statute, the Constitution and the different provisions. Short story, cop let me go, took those two away in the car. And I realized the power of information and the power of being, knowing the law. Skip ahead. When I got out of high school, I went to Israel. Again, it was back in the day when everybody was talking about communism, and that kind of thing. So I knew that in Israel, they had kibbutz. Kibbutz was the purest form of a commune. Everybody who's not familiar, it's a collective farm, and everybody's here by choice. And you work according to your ability, but everybody shares equally in the profits of the kibbutz. So I went to Israel. I lived on a kibbutz for a year, picked apples, picked oranges, picked pecans. And after a year, I said, this is great, but I'm not meant for manual labor. So I enrolled. The following year, I went to Hebrew University in Jerusalem. And that's where I studied for a year philosophy. Realized that that's not the greatest idea. I was a philosophy and English major. Yeah, go to a foreign country to study English. That makes sense. And I also had an interest in photography from high school days. So I decided to come back. I wanted to learn photography. And I came back and I went to a junior college, studied photography, and I became a professional photographer, primarily doing sports. And I did that. And then I went to Rutgers University when Rutgers was good athletic, had good teams, and I took pictures there. And that led to working with some good New York Times, Sporting News, and a couple of other, the NBA, a couple of other publications. Wow. After a number of years, I met somebody. I met an Israeli girl who was working here, ended up going back to Israel. And I spent 4 years as a professional photographer in Israeli newspapers. And then finally I said, okay, it's time to get a real life. It's time to join the real world. And I came back and I went to law school. So I went to law school in New York, which was great. After law school, my first job was at a insurance defense firm, and I did insurance coverage for 4 years, environmental pollution, where we dealt with the big cases, millions of pages of documents, and computerization was just getting started. When we started that case, we were putting all our documents on microfiche. You can believe that. We
I
had
remember that.
we had millions of documents. It was with one of the large chemical manufacturers. We had millions of documents, and we had hired a team of 5 people with microfiche units that had down there. And after people reviewing the documents, they were recording them on microfiche. So eventually, we got to scanning documents. That came later in time. But I learned quite a bit. Eventually, I left that firm, and I was on my own. And when I was on my own, I set up my office in my house. My dining room was my office. Uh, I had divorced a wife in Israel, and I met somebody else, and I got married. And she said, I want a dining room. You got to get a job. You got to get out of the house and get a job. So I sent out resumes, and I got I got an offer from Pressler and Pressler. I got that offer through an agency. Now, I had never heard. I'd been practicing for 10 years at that point. I'd never heard of Pressler and Pressler. Pressler and Pressler, for those who don't know, is the largest collection law firm I'd say in the Northeast. At that time, there were over 400 people.
Yeah.
This is back in 2001, 2002. Took an interview because I had a friend who had an office in the area. I figured, what the hell? If it doesn't work, we can go have lunch. So it'd be a nice afternoon. They ended up hiring me. The only thing they saw is that I was familiar with computers. That I knew a lot about. And I stayed at Pressler for 14 years as in-house counsel. The first 2 years I did collection work. I didn't make calls, but I went to court. I tried cases. I tried quite a few credit card cases when there was an attorney on the other side, both in New York and New Jersey. I worked with debt buyers pretty closely, and I learned the business from that side. Eventually, as people in the industry know, Pressler and Pressler got sued a lot back then. And I got so busy that I couldn't do anything but do defense. And I segued over to just defending cases on a regular basis. And that was my sole function. During that time, I met Manny Newburger, and we became friends. He worked with the firm. And we talked about eventually I wanted to broaden my horizons doing defense work, because while I was at Pressler, I was limited. I did actually have some outside clients, 1 or 2 law firms that hired me, but that was rare, since who's going to hire a competitor to defend them? That makes sense.
Sure.
But I actually did get a number of law firms in the area, in the New York metropolitan area, that I defended while I was at Pressler. But I wanted to get out. I wanted to just do defense work. And eventually I joined Barron Newburger. It's about 6.5 years ago.
Okay.
And that's the short answer.
That's the short answer. Okay. And so now you're with Barron Newburger, and your focus is still on the defensive side?
All I do is defense. I represent banks, law firms, debt buyers, collection agencies. I've represented some other companies because we've also been involved in FTC and CFPB investigations for other types of businesses connected to the financial services field.
Sure.
But
So as we started planning this this webinar or the podcast today and talking through some different ideas, one of the things that I found really interesting in our discussion was talking about kind of the timing of settlements from a defensive standpoint, and just kind of looking at the process, because I think negotiation is negotiation kind of no matter where it happens, right? I think the pillars of negotiations remain the same, but from a legal perspective, it feels like time is, there's time, information, and power. If you go back and you look at the Herb Cohen books, who was like the great negotiator, really of the late 20th century, you have time, information, and power. But it sounds like in your world, time is one of the most important pillars of those negotiations. Talk to me a little bit about what that kind of means and how you view the process of settlements.
Well, from a real perspective, as I told you when we were offline, I just got called in. I have a trial on Monday morning. Now, I don't expect the trial to go forward. It's a pretty complex case. It's a class action. There's motions that should have been made that haven't been made yet by the other side. And it's a case that I was looking over before we talked. And I see that we've been trying to settle it for about 2 years now. And the number keeps coming down. And once we asked for an adjournment, my adversary asked for an adjournment. He didn't get it. Yesterday, they said, we expect you in here Monday morning. Well, I've gotten several emails and the price is coming down. And it's my belief that it's not going to settle, if it settles at all, until Monday morning when we're actually in court and it becomes real and he's faced with the prospect of, now I've got to go forward. Now, as I told you, goes back to when I was doing collection work and calling people about a trial. Trials are on Friday mornings. And we learned something, that we would call somebody up on Monday or Tuesday, we'd have a collector call and try to settle it, and the debtor would hang up on him. Go to hell, I'm not talking to you. And that would continue. Thursday night, holy mackerel, cases started disappearing because it finally, it's until the reality in my world, until the reality of you're going to trial, you're actually going to have to appear tomorrow, sets in. And because 3 days from now, it's still not real. That's what I've learned. It's tomorrow morning. I got to get up tomorrow morning. I got to put on a tie. Then it becomes real. And that's when things get settled. The other, from that is, I was telling you, I had a big case in a prior career. And we spent a couple of days, three attorneys, getting ready for that trial. And I had a good feeling that we weren't going to it was never going to go forward. But we spent at least 3 days, three of us, really going through it. It was big, involved. It was concerning land transactions. And on Monday morning, prior to trial, it was settled, like at 8 o'clock in the morning. And I came into the belief that if we had not done that, if we had not done all that work, somehow psychically it went through the air, and the other side knew that we were ready to go, and they decided to settle. So I think that's another
the confidence in your statement,
right.
So it's the confidence in me being able to say, oh no, I'm ready. Like and like from a business to business perspective, we face a lot of the same things. We may be, having a disagreement with another organization. When it comes down to it, when I can make the statement, no, I'm prepared to litigate, it's okay. Right. They feel a lot differently about that. But I like what you say about kind of that last minute, right? I think it's when they got to go iron their suit and get that tie ready for the morning and, move their calendar around or whatever else it is that they have to do in order to appear in the morning, that it becomes very, very real. And so I think, and that's just human nature in general, right? Humans like to wait till the 11th hour in order to do anything. So it feels like it's a fairly normal process. Now, when you're talking about kind of that last minute settlement, do you think it's more the, let's say the defendant or the plaintiff or the attorney that's starting to push for it? Because I feel like not all attorneys are going to get as prepared as you're willing to get. Right. So if you're willing, like before you're going in there to make that statement, do you think that they're settling because they're just not prepared to go forward? Or is the realities of the cost and expenditures and everything else that's going to have to go into it start to become?
Well, in our space. So let's just, if we limit it to our space, remember, attorneys only get paid if they win. The big money in all of our cases is not on the damages, the liability issue. Remember, the FDCPA is a $1,000 statutory limit, and they don't get any more than that unless they can show actual damages, something real. And that depends, of course, from jurisdiction to jurisdiction, what's real and what isn't.
Sure.
Psychically, emotional, all that kind of stuff. But in general, I'm thinking any case, you've got 20% max for the plaintiff, 80% an attorney's fees. So really what they're negotiating, so when you understand that, what you're negotiating is their fees. What are their fees? Because that's what they're trying to recover, because it's easy. If you wanted to settle with a plaintiff, you could do that. Okay, here's $1,500, you're done. You got a letter, you didn't like it, so it's a violation. But realistically, but the attorneys, well, I need $10,000. And the reason is they figure that's what they want to compensate them. So you need to, if there's some question in their mind, and this really determines on the ability of the attorney, how realistic they are about their case and their prospects, because a lot of them aren't realistic. They just don't appreciate the variables and what can happen. Those that do are the easiest to negotiate with because they recognize that it's a risk. And as I like to tell people, which maybe the clients like or don't like, I say, I get paid either way, so I don't really care. I'm going to court on Monday morning. I'm getting paid for it. You, on the other hand, may not get paid, because if you can't get the settlement or win at trial, you walk away empty-handed. So maybe you want to think about a bird in the hand. And that's a part of it. That's a large part of it in our space. So if you convey that to them, and there are those that you can negotiate and listen to and say, here's some of the issues. There's attorneys.
So let me ask you this. Right. Is it more likely for an attorney to... I've got two different kinds of attorneys in my mind here when it comes to, I'm going to throw up consumer representation in air quotes, because the rest of my statement is probably a little more aggressive. Is it the ambulance chasers that are more likely to settle, or is it those that, are kind of one-off attorneys into the space? And by ambulance chasers, I'm referring to the, let's call it 10 different groups that literally are building a marketing plan around suing collection agencies, and they're spending money on search engine optimization, right? And they're doing literally lead generation like any other type of organization, because they're trying to sell a product. The product is sue the collector.
So
now, on the flip side, you get like regular attorneys. That's somebody's buddy going in there. So, like, how do you view the difference between those two worlds?
Well, I think there's more variations on the ambulance side. Let's start with the one that you never see again. That they just, most of the time, they're really not familiar with this area.
Yeah,
99% of the time, they've never handled a case in this world before. They really don't know, and they're relatively easy to negotiate with, actually.
Okay.
And most of them, you get a couple who think, because they don't understand, this is $100,000 case. And it's like, you laugh at them and say, you have to try to educate them. But many of them, it's especially when they're helping a friend, and you want to find that out. If all they're doing is helping a friend, or this is a client that they have for a lot of other things, and they're just trying to do them a favor in a sense, it's a lot easier to negotiate and get rid of it, because they're not looking for big payday. Their livelihoods do not depend on this case. So that makes a difference.
Fair.
Now, let's switch over to, there's the ambulance chasers. There's those attorneys who are filing in mass. And a lot of them, for $2,000, $3,000, $4,000, they're going to go away, because that's their model. Their model is to sue and to take a lowball settlement, and based on volume, they make a lot of money.
Yeah.
And those are the people that people complain about, and end up costing, if you want to litigate, you can beat them relatively easily. When I say easily, but not relatively cheaply, because you've got to spend the time and money. And I'll throw out a name that a lot of people on this, anybody who's listening will have heard of it. It's David Barchet, New York. His suits are worthless most of the time, 95% of the time. They're baseless. But he's got a form complaint, which is 30 pages. You've got to deal with it. It's time and money. You've got to go after him. So you could he'll end up settling for $2,000 to $3,000. And from a business perspective, that makes good sense. However, he will then come back, and everybody's heard the analogy, the stray cat analogy. You leave milk out once, they'll just keep coming back. So you want to be an ATM.
Agreed.
So you need to fight. And, I'll go back for a second. At Pressler, it was great because I didn't have to settle ever. I could litigate every case I wanted to, because I had the time and I had the money. And a number of people who sued us a lot eventually stopped suing, because they realized it was going to be a dogfight. I was going to never, ever set, unless they had an actual valid claim. If they had a valid claim, and I will say this, if you got a valid claim, settle it as quick as you can. Don't, that's not the time to puff at
to dig in and fight.
Yeah,
agreed.
No, that one you want it, because you don't, again, remember what I said about, it's legal fees that are driving it. The more you litigate, and you've heard about cases where they were really piddly violations, but somebody went all the way, went to trial, and then they ended up losing. And the debtor got $100, $200 in damages. but the law firm got 100,000 in legal fees, and that will happen. So that's something you have to be concerned with. So going back to, so you got that group of the ambulance chasers, the real low end who are just filing a mass. Then you've got a group, the true believers, and those are with the consumer groups who actually believe philosophically that what you're doing is wrong and they want to stop that. And they're difficult to deal with because it's not about the money, it's about the idea. And sometimes some of them you can work with by making their client, they do care about their client. In often cases, they have more concern. They're easier to deal with in terms of their clients because they have more concern for their clients' well-being. And if, for instance, if you can write off a debt and get rid of it, that means something to them because they're getting their client out from under. And then you've got the guys who are not filing in mass, who are all about the money, and they're businessmen, and they're looking at it from a business perspective. So you've got a number of attorneys. They'll file cases as a class action, but to be willing to settle it on an individual basis to get a payday. And that's something that people don't understand. I'm not sure everybody understands. When they have a class action, which is a legitimate class, and a legitimate class means they're not going to have any problem getting a class certified. A letter case. They sent the same letter. It went out to 1,000 people. The same violation as every letter. So that's by definition going to be a class. So you offer to settle that. They're giving up what they could make on the class case. If they put through a class, there's legal fees involved, the time and effort that they put into going. Even if you consent, even if it's not contested, they still have to put it because they've got to make a motion, they've got to prepare papers to file. So it's a lot of time and money that they're going to make. That's a guaranteed if they've got a violation. So if you offer to settle it individually, they say, yeah, but I'm giving up $30,000 in legal fees. So you got to give me a premium. So you can't settle it as if it's an individual case where I haven't put, because here I've got a guaranteed payday. So you pay them a premium. So it's going to cost more to settle a case like that on an individual basis than a class, than an individual case, which is brought as an individual. And then you've got the last group, which are going to litigate forever and try to wear you down. And there's a number of them out there who have some skills, and you've got to be prepared to go toe-to-toe with them forever. I mean, the case I was talking about that I'm going to trial on Monday, I'm going to court on Monday. We've been litigating this for 4 years. I mean, this is like the old days when I used to do the cases which took several years. Discovery went on forever. There were motions, and we went to court a lot. These are real cases. These have to be litigated like real cases, and there's a lot involved. So, and then those you have to actually know what you're doing.
Yeah. Well, it's interesting to see the business of law that unfolds from the consumer perspective, right? There's a business in defending organizations against these, whether they actually made a mistake. I feel like, at least from the seat that I sit in, a lot of the suits that I've seen over time, and as a compliance professional in the space for over 40 different groups, most of it was not legitimate. Most of it was form letter, TikTok video driven kind of bullshit. And a lot of that is in terms of the ambulance chasers. I've literally built a business around helping collection agencies and debt buyers protect themselves from these types of, I'm going to call them marketing attacks, by doing reputation defense work. And quite literally, that's where this podcast came from, right? The whole idea for doing these kinds of things came from the ability to try and protect. Now, I also believe in consumer protection, right? And call that a paradox, but I believe that the consumer should be protected. And if organizations are getting really out of line, that's a different story altogether. But it's those attorneys that have made a business out of cultivating leads in order to generate nuisance lawsuits, I believe needs to be addressed by, I don't know who, the court system, or whose responsibility that becomes, because I'm not a lawyer, thank God. I'm lucky enough to have some great relationships with people like you to advise me on those types of things.
Look, one of the after effects of the CFPB and the rules is that people in our space who get involved in organizations so they keep up, are getting better and better educated every day. and making fewer and fewer mistakes or slipping through the cracks. What's the effect of that is a lot of the attorneys on the other side who have made a career out of suing on the FDCPA, the FCRA, the TCPA, who have no other skills. They've never done anything else. And this is a relatively easy area because you don't have a lot of facts involved. So they're losing, and I've heard this from a number of plaintiffs' attorneys. I'm not getting cases anymore. They're not. I'm just, my business is down. So what they're doing is they're trying to get more and more creative, as opposed to finding something else to do. Maybe you should practice another kind of law, learn how to practice. They're looking for more and more issues. And by way of example, this is a local New Jersey issue, but New Jersey, there's a licensing act, which they've been trying to apply to debt buyers. And this started about 7 years ago, actually 8 years ago. But what's happened is the debt buyers, and I was asked back then, do I think they need it? And I said, I don't, but it's going to cost $1,500, something in that neighborhood, to get the license. Just get the license. Who cares? Whether you believe it's needed or not, it protects you.
Is irrelevant.
Yeah. It's so cheap.
It's relevant.
Doing business because one lawsuit's going to cost. So everybody started getting licensed. So all of a sudden, no more suits. You couldn't sue the direct. So what happened next? And it's one particular attorney. He started suing if there was somebody in the chain who wasn't licensed. So when you had a bank that sold it to debt buyer A, then debt buyer B sold it to debt buyer C, and then your client is debt buyer D. Now your client was licensed, and maybe even the debt buyer that they bought it from was licensed, and the bank doesn't need a license. But somewhere 10 years prior in that chain, there was an
prior to the need for a license. Yeah.
And I have two cases like that, which are now suing that they weren't licensed. Now, will they win in the? I don't believe so. But that's what they're doing. So they're looking through, especially when debts are going through multiple parties. So this is one of the new, how what can they come up with?
Well, they changed their strategies for lead generation too, because originally it was, I'm going to build a web page on my website that talks about debt buyer A and how bad they are, right? Call me instead of paying them. And they would show up in the Google search results. And then debt buyer A hires a company like Branding Arc to come in, fix that problem for them. And what's the attorney go and do? They start running ads. They start actually paying for Google advertisements in order to jump over the organic results that have been created. And that becomes the battleground for a lot of this lead generation, is ultimately turned into search engine results pages on Google, which is entertaining on some level, but also very frustrating and difficult, because now I have to spend ad dollars in order to offset their ad dollars until they finally go away and go focus on a lower hanging fruit. But to your point, I think that they are very much focused on the low hanging fruit as much as possible. It's interesting to learn that dynamic, Mitch. I really do appreciate you coming on to the podcast today and sharing your insights, because this has been a fantastic conversation.
I want to point out two more things to what you just said.
Sure.
There's two other areas where they're getting leads. One is debt relief companies. You find that a lot of attorneys have been working with debt relief companies and are feeding them. We got a recent guy in New York, he's sharing the office. Not the suite, but he's in the same room as the debt relief guy. So it's kind of like they're working in tangent. The other is a lot of are using aggregators, and they're getting boxes of letters that they pour over, that these guys collect from debtors, and they're pouring over them and then contacting the debtors. We see you have a problem. Of course, the debtors don't know. Keep in mind, that's, if you haven't, but I have deposed the debtor. So when you got this letter, what'd you think? I didn't think anything. I threw it away. I ignored it. And you got an attorney saying, hey, I need $100,000 for the damages. What happened? That's real. That's I'm not making that up. So,
oh, God help us.
Yeah, that's the world we live in.
Well, Mitch, I really do appreciate you sharing your insights with me today. This has been a fantastic discussion. For those of you that are watching, if you have additional questions you'd like to ask Mitchell or myself, you can leave those in the comments below on LinkedIn and YouTube. We'll be responding to those. Or if you have additional topics you'd like to see us discuss, you can leave those in the comments below as well. And hopefully I'll be able to get Mitchell to come back at least one more time to help me continue to create great content for a great industry. But until next time, Mitchell, when I get to see you in person at one of the many shows that we attend together throughout the year, I really do appreciate your time and attention today.
Well, as I listened to a podcast earlier today, I'll see you in New Orleans, apparently.
I will see you in New Orleans for NCBA. But for everybody watching, thank you so much for your time and attention today. We'll see you all again soon. Bye, everybody.